they're trying to bait me and bait the court when they are trying to paint our position as saying somebody's above the law. If somebody commits...
No, I'm trying to get you out of the Revolutionary War and up to here where there's an argument about whether or not you're subject to certain laws in the state of New York.
RCL gives
or
us
not,
the right.
And if
yes. Sorry.
I mean,
it gives...
Your Honor, I was anxious to answer.
Well, I didn't know what the yes ends up being a yes to because I hadn't finished my question, but I'll come back.
Okay. May I ask you?
No, go ahead. Please
okay.
go. Please
If you could,
the RCL,
if you could clarify something here. Well, go ahead. Finish the RCL.
Okay. In my effort to respond to Justice's question, the RCL specifically says in the event of a conflict, the RCL prevails. Section 5 specifically builds in and vests the religious organization with the right and the obligation to follow the teaching and the usages. If one goes to the bylaws, and these...
Isn't that in spiritual matters, though?
Well, no. And that's why it's important to go in. This has been explained by the three experts in the record. Shlomo Globerman, who was so upset when he was the authority presented by the other side originally, without consulting with him, and then he put in an affirmation in the record saying that they're misquoting me, they're stating the history of the Sabbath.
I mean, I guess what's bothering us, I think, is you say you are subject to the religious corporation law and the not-for-profit law where it applies, but they've brought a proceeding under Section 618, which you say is not justiciable. And would any proceeding applicable to this corporation ever be justiciable in your view?
Well, of course, there's no question. The answer is yes. Direct answer to your question is yes.
There could be proceedings that are justiciable, but this isn't it.
This isn't it.
Why not?
Obviously, the congregation's been a party to disputes where it doesn't involve a dispute that's internal to the congregation.
Well, but 618 is by its nature for settling internal disputes.
Yes, but in response to whether the congregation could ever be subject to a justiciable dispute in the civil courts.
Well, could it ever be subject to review under Section 618?
Could it be? The congregation, the answer to your question is that the congregation believed it was a nullity because the election itself, and this goes back to your question, was called by somebody who had been removed by the highest ecclesiastical
You're talking about their election.
Authority. Their election.
But they say, is your election subject to review?
Not according to the United States Supreme Court and not according to the decisions of this
court. You say that's because it would involve a determination of a spiritual issue.
I don't believe, yes, I don't believe.
Let me ask you this. Suppose they had seized by self-help, seized possession of the congregation, and you said to evict them. Is that justiciable?
If they had seized?
Yeah, they're sitting in your offices. They walked in, occupied the offices. You're bringing an eviction proceeding. You say we're the officers, they say we're the officers. Is that justiciable?
If there's violence involved, as there had been in this case.
I didn't quite say violence.
Well, okay. We believe, we are bound, when we become a member of the satmar community, a voluntary association, you agree that any dispute that is intra-congregational must be taken to the highest ecclesiastical authorities.
Your implicit answer is that's not justiciable.
Not in the civil courts, under the satmar, under the doctrine, and that's what's so critical, and that's what
isn't that a problem? Isn't that almost an invitation to self-help? And isn't self-help sort of the last thing we want to encourage here?
If the Grand Rebbe had authorized going, or the highest ecclesiastical authorities, as has been done in certain cases, as has been done here in one instance, authorizes resort to the civil courts, then it's permissible. If there's a violation of civil law, such as an assault or physical invasion of a sanctuary.
Well, why isn't an improper corporate election a violation of civil law?
Because, and this is absolutely critical, in essence, people have a right, if one enters into a binding arbitration agreement, if you and Justice Kaye enter into an agreement and you provide that any dispute arising from the matter will be heard binding arbitration, then either one of you do not have a right to seek relief in the court unless it's in aid of arbitration.
Well, you can bring an action, and then there will be a determination that there's binding arbitration or not, but there's a civil judgment in the matter. If, as happens here, someone conveys real property, shouldn't there be some type of a determination by the courts of the state as to whether or not that conveyance is valid or not?
Well, the answer is it depends. And the reason it depends is you have to determine, is it truly a dispute involving neutral principles of law? 2 members of this court have sat on one of the cases involving the issue of a real estate dispute in an intra-church fight. It was a church fight between a smaller church and the mother church. And in that particular case, the court said that because neutral principles of law could be applied by looking at the actual real estate documents, looking at documents that did not involve intruding on church governance, what the Supreme Court in the Serbian case
You don't want us to look at the neutral principles. You don't want us to look at the bylaws or the statutory framework. So you're saying that this dispute could not be judged within that framework.
If what the Supreme Court has said is, and it's been misstated in the brief, we are not saying that there's no standard for applying neutral principles. What we're saying is if one reads the cases clearly, they say a court may choose to apply neutral principles of law. In determining whether you can apply neutral principles of law, you have to take a look and say, in order to do that, must I get involved in ecclesiastical philosophy, discipline, church
just stop
governance?
there for a moment. What is the ecclesiastical doctrine that precludes looking at how the election was conducted?
Okay. Fundamentally, within the satmar community, as has been explained by 3 experts, one of whom had been cited as an expert in a case that you decided, Justice Kaye, Mr. Rubin. But in this, becoming a satmar, when the first Grand Rebbe came to America, he set up an organization that said, I am the highest ecclesiastical authority. I will judge whether you are living according to Torah, according to the ways of our forefathers, according to Code of Jewish Law, a 16th century treatise, multi-volume treatise.
Assuming all of that, that doesn't pertain to how you elect officers.
If someone has been, it says in the bylaws specifically, and it says in the bylaws that no one may occupy their position without the consent of the Grand Rebbe. Remember, anyone is free to join a different organization. This is a voluntary organization. And the bylaws themselves say, and it's interesting, there are 3 sets of bylaws in the record, the neutral, what they call the neutral bylaws, our version of the bylaws, their version of the bylaws, their version of the bylaws confirm that no one may hold their position without the consent of the Grand Rebbe.
Aren't the words spiritual matters used when the power of the Grand Rebbe is referred to in the bylaws?
The answer, Your Honor, is yes, spiritual, but there
What is spiritual about electing officers?
Well, first of all, Your Honor, spiritual is, you asked me the question, is spiritual mentioned? And the answer is yes. However, the bylaws go far beyond that. And
it says he is the only authority in all spiritual matters.
It also says that he is the head of the religious court of Satmar. They've tried to give the impression that there is no ecclesiastical court. I couldn't believe that they, in their papers.
Who's the head now since he died?
Rabbi Zalman.
Can I ask you a question about that then?
Yes.
If you go back to the January 14th, 2001 election, and there's claims of quorums, not quorums,
right,
everything else. They do whatever they do that day. If the Grand Rebbe says that's who I declare wins, does he win?
Without question.
All right. Regardless of whether there's a quorum, regardless of whether there was no quorum, regardless of any violation of the bylaws of the organization, he can simply declare a winner, right?
Absolutely, and in fact,
so has he done that here? In other words, can you come in with a document that says he's declared it, so this is all moot?
Yes. The answer is yes. After our election, in the record, you have the certification by the Grand Rebbe. You also, in addition to the certification by the Grand Rebbe, you also have the
Isn't that
certification...
disputed? Isn't that certification disputed?
It's interesting. The answer, not really, Judge, and I'll explain why.